The finances of a whistleblower case. There are two important parts of this. One, when a case is settling, how is the settlement amount calculated? And two, once the settlement has happened, how much of that money does the whistleblower get? When you're evaluating whether to file a whistleblower case, obviously one piece of it is to assess the finances. And there are two parts of that. There's the cost, which includes the retaliation you're going to face, the cost of your time, lost salary. And then there's also the potential upside. If you have a successful case, if there's a recovery, how much do you stand to gain? In evaluating the potential upside, there are two key parts of that. One is when the case settles, how is the settlement amount calculated? And then the other is, of that settlement amount, how much of that money do you as the whistleblower stand to get? I'm going to talk about both of those, and in rough terms, there's a lot that goes into it, but in a back of the envelope kind of way, there's a pretty standard way that both of these things happen. In terms of how settlements happen, how they're calculated, obviously there's a certain amount of horse trading that goes on at the end of the day. But as a starting point, the government really likes to take a reasoned approach to its negotiation of the settlement amount. The starting point for that is the statute. The statute says that under the False Claims Act, defendants can be required to pay up to 3 times the damages caused by the fraud, and penalties of, and depending on the statute, 5, 10, 20,000 or more. When you look at the amount of an actual settlement in a case, and you want your case to settle because that it's quicker, it is more reliable, you're more likely to be successful if it settles rather than going to trial. As a starting point, just throw out the penalties. Penalties are almost never part of a settlement. Usually you're only going to see penalties at the end of a trial. One of the reasons you often get a settlement is so that the defendants can avoid paying penalties. So when you're looking to assess how big your case might be, you need to start, just take those off the table. So then what you're looking at is starting with the actual damage caused by the fraud, what's called the single damages. Look at the claims. What were the false claims that were made, and what harm did the government suffer because of it? How much money did the government pay that they wouldn't have otherwise paid? You start there, and then you look at the multiplier. The statute allows a multiplier of up to 3. As a practical matter, settlements are usually closer in the 2 to 2.5 multiplier range, and sometimes they're even lower than that if the defendants were cooperative with the investigation, if they came forward on their own, or even if they didn't come forward first, if they helped the government once that they knew that there was an investigation. But then after that, the part that really makes a difference is the government applies a factor called litigation risk. And what that means is, how hard would this case be to win if we go to trial? How expensive would the case be to take the trial? How good is the evidence now? What kind of evidence can we get? All of those factors go in to assessing the amount that the government is willing to take off the damages amount to reflect that this might be a difficult case to win. So as a practical matter, if you have a case that the damages are really big, but it's kind of an innovative case, or man, it's going to be tough to prove, then the government is going to apply a factor to reduce that amount, the settlement amount, to reflect that difficulty in order to get the settlement. So once the litigation risk factor is applied, then basically the government and the defendants negotiate and ultimately reach a settlement amount. Once you've reached that settlement amount, the question then becomes, you as the whistleblower are entitled to a share of that. How is that share calculated? To talk through that, I'm going to move over to the whiteboard. To understand how much money you could make with a whistleblower case, let's walk through a rough and dirty calculation. So your case has gone well. The government has settled for $10 million. And so the question is, how much of that do you stand to possibly gain? There are a lot of factors that go into it, but they follow a relatively standard set of steps. The first is what's called your relator share, your piece of it. It could be between 15 and 30% of the case, sometimes more, sometimes less than that range, depending. As a practical matter, because it makes the math easier, we're going to use 15% for this example. Also because when you're evaluating your case, you really want to think pessimistically. You want to think, does this case make sense if it goes badly or not as well as it could possibly go? So 15%, your relator share would be $1.5 million. From the government to you. From that amount of money, next you need to pay your lawyers their contingency fee. Different lawyers charge different fees. I'm going to use 40% here. That's a relatively standard amount. That's the amount that I typically charge. 40% means after paying that, you have $900,000. Then you need to pay the tax man. That is where things can very much vary, and you should talk to your accountant. It varies based on the state you're in, how you structure your finances. But again, if we're going to be rough and dirty and maybe a little optimistic, let's say 40% to Uncle Sam and maybe to your state. So 40%, and here the math gets a little more difficult. 60% left to you is $540,000. After taxes. So $10 million settlement to the government. After you get your relator share, you pay your lawyer, you pay your taxes. That leaves you with $540,000. So as I said before, these are just rough estimates. There are a lot of factors that go in at each step of the way. If you would like to get more information to talk through your specific case or situation, please feel free to contact me for a free confidential consultation.